Hello, and welcome to Delhi Law Firm. Today we bring you a highly important and far-reaching judgment, a decision that started as the fight of one ordinary consumer but ended up benefiting the entire nation. This is the Delhi High Court judgment in Sarwar Raza versus RBI Ombudsman in Citibank, the historic 2025 decision. This judgment has for the first time made strong and clear observations on India's banking grievance mechanisms, the functioning of the RBI Ombudsman, the conduct of recovery agents, and consumer rights. We will understand this entire case in detail, its facts, arguments, legal analysis, and most importantly, what changes this judgment has brought for the whole of India. Listen carefully because this knowledge can protect not just you, but any banking consumer in this country.
You're absolutely right. This case began as a simple credit card fraud, but it ultimately exposed the weakest part of India's banking system, the grievance redressal mechanism. The court stated very clearly that RBI's ombudsman system is functioning like a machine, mechanically rejecting complaints rather than serving consumer interest. Imagine a victim approaching the ombudsman for justice only for their complaint to be rejected by a software or auto-generated system. Can this be called justice? This question alone made the entire case so important.
So let's start from the beginning. In January 2022, Sarwar Raza, a practicing advocate in Delhi, was issued a credit card by Citibank. Everything seemed normal. A few months later, on 5th April 2022, the bank suddenly issued him a second card without any application, without any request, and without any permission. The customer didn't even activate the card. Yet the very next day, on 6th April 2022, a huge fraudulent transaction of 76,777 rupees was made on Paytm Rent Payment. This incident by itself was shocking.
And when the customer received the email statement on 12 April, he discovered the fraud for the first time. Immediately, he filed complaints with the bank and the cyber cell. At first, the bank gave him a provisional refund, and it seemed the matter might be resolved. But just a few months later, the bank closed the complaint and declared the transaction genuine, claiming it occurred using APIN, IPIN, and OTP. This is a routine defense banks use. That OTP went to your mobile, you must have shared it. But here, the biggest question was, to which number was the OTP sent? Because the customer insisted he never changed his mobile number.
And this is where the entire case turned. The customer's registered mobile number had been changed in the bank system, but the customer knew nothing about it. This is one of the most common cyber fraud methods, SIM swap or OTP redirection. After this, the bank reversed the provisional refund and began charging the customer interest and penalties on the disputed amount.
When the customer approached the RBI Ombudsman hoping for justice, he filed 2 complaints. But shockingly, the Ombudsman auto-rejected both complaints. The first was rejected because it was filed through an advocate, and the second because one column was filled incorrectly. And these rejections were not made by any human officer. They were system-generated. Basically, a computer program rejected the complaints. It's like replacing a judge with a robot who decides someone's fate at the click of a button.
Can this be called justice? This question alone made the entire case so important.
When the customer approached the High Court, he faced yet another blow. The court ordered the bank not to take any coercive action while the case was pending. But the bank violated this order. They sent a demand notice, made recovery calls, and even sent recovery agents to the customer's home. The recovery agents told him to settle the matter by paying 80,000 rupees. The court took this very seriously and the customer filed a contempt petition.
When the court summoned the general manager of the bank, the court asked a simple question. Who is responsible for sending these automated emails? Who is the officer in charge? And the court made it clear that this question was not just for one bank. It targeted the entire banking industry. The court said consumers have no idea where their complaints go, who is handling them, who is deciding them. This lack of transparency is a violation of consumer rights. Now let's come to the court's analysis. The court said the manner in which the mobile number was changed still remains a mystery. The bank could not provide any logical explanation. There was no clarity on which number the OTP went to, but the court also said that a writ petition is not the place for forensic investigation, so it would not decide that issue here. However, the court made one thing clear. Consumer harassment is unacceptable under any circumstances.
Now comes the most powerful part, the High Court's final directions. The court issued 7 major directions. Direction 1. The bank cannot charge any interest, penalty or fees on the disputed amount. Direction 2. The consumer's CIBIL score must be restored immediately. Direction 3. The bank must pay rupees 1 lakh compensation to the consumer for the misconduct of its recovery agents.
Moving on, Direction 4. The RBI Ombudsman cannot reject any complaint through automated systems. Every complaint's final rejection must be made by a human authority, specifically a legal professional with at least 10 years of experience. This is a revolutionary change in India's banking grievance system.
Direction 5. The RBI must increase staff at ombudsman offices to ensure complaints are handled properly, fairly, and in timely manner. Direction 6. All banks must display a clear complaint handling flowchart on their websites showing how consumers can escalate their issues. Direction 7. The RBI Deputy Governor must report to the court by 15th January 2026 on how these directions have been implemented.
The impact of this judgment is massive. Every banking consumer in India can now feel relief. Banks can no longer hide behind automated systems. Recovery agents' misbehavior will now cost the bank directly. Fraud-related CIBIL damage will no longer destroy someone's financial life. And most importantly, justice will not be delivered by a machine but by trained human authorities.
This judgment is a landmark in the history of consumer rights in India. Digital frauds are increasing rapidly, and the judiciary has taken it upon itself to protect consumers. This judgment shows that the law stands firmly with the consumer, no matter how big the institution on the other side.
If you too are facing any bank fraud, wrong transaction, credit card dispute, fake recovery call, CIBIL drop, or ombudsman rejection, this judgment is your strongest weapon. Know your rights and take the correct steps.
If you need help with your case, contact us. Delhi Law Firm handles cases across India. For more information and assistance, visit www.delhilawfirm.news.